Okay, so welcome to the deep dive. We're diving into something super important today if you're renting in California, your rights as a tenant. I think we can all agree renting and figuring out all the legal stuff can be, a little confusing. So in this deep dive, we really want to break it all down and make it clear what matters most, especially if you're listening in Orange County, Riverside, San Diego, or Los Angeles.
Yeah, that's right. California actually has laws to help protect renters, but you got to know your rights and what your landlord is supposed to do. And that's like the first step to making sure your time renting is fair and secure. We went through a ton of info to bring you the really crucial details.
Perfect. And that's what we're going to zero in on. Those key things, like how to be sure your place is actually livable, the whole security deposit situation, and what happens if eviction comes up. This is stuff that can really give you some power as a renter.
So let's jump right in. Let's start with one of the most basic rights. The right to a livable home. This isn't like just a preference. It's a real legal thing in California. It's called the implied warranty of habitability.
Okay. Implied warranty of habitability. That sounds pretty serious. So what does that actually mean for you when you're renting?
Well, basically it means your landlord has to keep your place safe and livable, not just when you move in, but like the whole time you're there. And the important word there is implied. It's a right you have under California law, even if it's not written down in your lease.
So what does safe and livable actually look like in a real apartment or house? What are some examples of those minimum standards a landlord has to meet?
Think about the things you need for a home to function, like effective waterproofing, so rain and moisture stay out. You should have windows and doors that close and lock right. Working plumbing is a big one. Hot and cold water, a toilet that flushes, and a kitchen sink that works. Then there's heating and electrical systems. Those got to be in good shape, too. The place should be clean, too. No pests and not a ton of junk laying around. And enough trash cans. Floors, stairs, railings, all that stuff needs to be safe and well-maintained. You should also have deadbolt locks on your outside doors, no lead paint hazards. And this is a big one. It should be free of stuff like illegal drug dealing that's happening right there on the property. Things that can mess with your health and safety. These are just the basic things you should expect under the law.
That all makes total sense. So what happens when a landlord isn't doing what they're supposed to? Like they're not keeping things up to the standards. What can you do as the renter?
So California law gives you a few ways to handle it when a landlord isn't keeping up their end of that implied warranty of habitability. One thing is rent withholding. Basically, if your landlord doesn't fix things after you've given them proper written notice and a reasonable amount of time to get it done, you might be able to legally hold back on paying rent. But here's the catch. You really gotta follow the right steps. It's usually a good idea to talk to a lawyer, someone specializing in tenant rights, before you do anything. You don't want to accidentally put yourself in a tough spot.
Yeah, rent withholding sounds like it could be kind of risky if you don't do it exactly right.
Yeah.
So is there anything else renters can do if their place isn't livable?
You bet. There's something called repair and deduct. It means that under certain specific situations, you can pay for essential repairs yourself and then just take that amount off your next rent payment. But there's a limit. You can only do this up to the cost of 1 month's rent.
Specific situations, huh? What does that mean exactly?
Right. So first off, the problem has to be something big. Like it's got to really affect whether you can live there comfortably and safely. Things like no heat in the winter plumbing that's constantly backed up, or electrical problems that are actually dangerous. Number 2, you have to give your landlord written notice about the problem and enough time to fix it themselves. And you can't have caused the damage yourself. You're limited to using repair and deduct only 2 times in a 12-month period. Lastly, the repairs have to be done the right way, either by someone who's licensed to do that kind of work, or if you do it yourself, you got to know what you're doing and do it properly. Keep all your receipts and records for everything. Oh, and remember, you can only deduct up to 1 month's rent.
So it's for the big important fixes the landlord is ignoring, not for any little repair you want to make. What if things are really bad in your apartment, like really unlivable? What can you do then?
Well, if it's so bad that you can't reasonably live there, then California law says you can actually move out and you're not stuck paying the rest of the rent on your lease. It's sometimes called constructive eviction. But heads up, just like with the rent withholding and repair and deduct stuff, you got to do things the right way. Give your landlord proper notice about what's wrong and give them a reasonable chance to fix it before you move out, and document everything really well. All those unlivable conditions, I mean.
Makes sense. Now, what if those options aren't enough, or if you really want to force the landlord to make repairs? Can you take them to court or something?
Yep, you can actually file a lawsuit to make them do the repairs. And if the court agrees with you, they can make the landlord fix things. You might even get some money back for all the trouble you went through because of the bad conditions. But to win your case, you'll have to prove that the problems are serious. They make the place unlivable, you didn't cause them, and you let the landlord know about them.
Okay, so we've covered a lot about having a livable home. Let's move on to something that always seems to cause confusion and arguments. Security deposit. What's the point of a security deposit anyway?
Well, a security deposit is basically money you give the landlord to kind of guarantee you'll follow the rules of the lease and to cover any potential damage you might cause beyond normal wear and tear. California has specific rules about how much they can charge and what they can use it for.
So how much can a landlord ask for in California?
If the place is unfurnished, the most they can ask for is 2 months' rent. If it's furnished, they can go up to 3 months' rent. That's the max, though they can't charge more than that.
Got it. So what are the only pruny-by reasons a landlord can take money out of your security deposit when you move out?
There are only 4 reasons that are legal in California. Number 1, if you owe any rent. Number 2, to pay for repairs that go beyond normal wear and tear stuff you or your guests did. 3, to pay for cleaning to get the unit back to how clean it was when you moved in. And last, if you break your lease early, but only for the actual money they lose because of it.
That's really helpful to break down. You mentioned normal wear and tear a couple times. Can you explain what that means?
Sure. Normal wear and tear is basically stuff that happens naturally over time as you live in a place, like little scuffs on the walls, paint fading a bit, carpet that's a little worn in high traffic areas, or doorknobs that get loose from being used a lot. Landlords can't take money from your deposit for those kinds of things. But if there's big damage like broken windows, huge stains on the carpet holes in the walls that weren't there before, that's usually considered beyond normal wear and tear. So they could deduct for that. It's a good idea to take pictures and videos of the place when you move in to prove what condition it was in, just in case you have a disagreement with the landlord later.
That is a really smart tip about taking pictures. Now, when you move out, how long does the landlord have to give you back your security deposit?
Yeah.
What are they supposed to give you along with it?
They have 21 days after you move out to return any part of your deposit they're not keeping. And they have to send you an itemized statement. It has to list every single deduction they made and why, and if they paid someone else to do repairs or cleaning, they have to include copies of those bills or receipts too.
Okay, what if they don't do that? Are there consequences for them?
Oh yeah, for sure. If a landlord doesn't return the deposit or send that itemized statement within those 21 days, they could end up having to pay you back the whole deposit. And if a court decides they were keeping your deposit in bad faith, meaning they didn't have a good reason to make those deductions, they could have to pay you even more than that, like up to twice the amount of the deposit plus the actual damages.
Wow, so there's a huge incentive for landlords to follow the rules then. Is there anything renters can do before they move out to avoid having problems with the security deposit?
Yes, definitely. California law says you can ask your landlord to do an inspection of your place before you move out. This inspection should happen a reasonable amount of time before you leave. It's basically so you can see if there's anything the landlord might take out of your deposit for. That way you can try to fix those things before you move and maybe avoid losing any of your deposit. It's a good right to use if you can.
That's awesome advice. Now let's talk about rent increases. That's a big worry for a lot of people. So what's the deal in California? When can a landlord raise the rent and how much notice do they have to give?
Landlords can generally increase the rent in California, but they have to give you proper written notice. How much notice depends on the size of the increase. If they're raising it by 10% or less in a year, they have to give you at least 30 days notice in writing. But if it's going to be more than a 10% increase in that same year, then they have to give you at least 60 days notice. This is to give you time to figure out if you can afford it or if you need to find a different place to live.
Do those notice rules always apply in every rental situation in California?
Those are the rules for what are called periodic tenancies, like month-to-month agreements that just keep renewing automatically. If you have a lease for a specific amount of time, like a year-long lease, then usually the rules about rent increases are spelled out in that lease. It'll say if they can increase it during the lease and by how much. And it's really important to note that a lot of cities and counties in California have their own rent control laws. Those laws can be even stricter about how much and how often rent can be increased. So you should definitely check with your local government to see if any of those laws apply to your situation.
Yeah, it's always good to know what the local laws are. Okay, this next one is about something that can feel really intrusive, your landlord coming into your rental. So what are your rights when it comes to privacy in your own place?
You definitely have a right to privacy in your rental in California. Landlords can only come in for very specific reasons. It's usually for emergencies or when they need to make repairs or improvements that you both agreed on or that are absolutely necessary. They can also come in if they need to show the place to potential renters, buyers, lenders, appraisers, or contractors, or if a court says they can.
So a landlord can't just pop in whenever they want just to look around?
No way. Unless it's a real emergency, they legally have to give you reasonable advance notice before coming in. Exactly what reasonable means can depend on the situation. But usually 24 hours written notice is the standard in California. That notice has to say the date about what time they'll be there and why they need to come in.
What happens if they break those rules and come in without notice for a good reason?
If your landlord does that a lot and on purpose, and if it seems like they're doing it to harass you or make you want to move out, it could be considered harassment. In those cases, you might be able to sue them and get a civil penalty for each time they entered illegally.
Wow, that's good to know. Let's talk more about landlord misconduct. What is considered harassment, and how are tenants protected from that?
Harassment can be a lot of things. It could be threats, either with words or physically. It could be trying to scare you or intimidate you. And like we talked about, entering your place illegally. It could also be things like messing with your utilities, like turning off your water or electricity on purpose, or making your living conditions so bad that you feel like you have to move out, and they're doing it all on purpose to force you out illegally.
So what should you do if you think your landlord is harassing you?
The most important thing is to document everything. Keep a detailed record of what happened, when it happened, where it happened, and if anyone saw it. If it's safe and legal where you live, you might even want to record your conversations with them. Then write a formal letter to your landlord. It's best to send it by certified mail so you have proof they got it. In the letter, tell them to stop the harassing behavior right away. Keep a copy of the letter for yourself. If you ever feel physically threatened or unsafe, you need to call the police. You can also get a restraining order from the court against a landlord who's harassing you. And if they've threatened to hurt you or use physical force, you can sue them for money, and in some cases, you might be able to get a lot of money from them.
That sounds really serious. What about illegal lockouts? I think we touched on that earlier.
Yeah, this is a big one for renters to understand. Your landlord or anyone working for them cannot lock you out of your place, change the locks, block you from getting in, or take out your stuff to try and evict you without going through the proper legal process in court. Those are all illegal. It's called self-help eviction.
What are you supposed to do if you come home and find out you've been illegally locked out?
If that happens, you have the right to get back into your place right away. Call the police immediately. What the landlord did might be breaking the law, the California Penal Code. You should also send your landlord a written demand right away telling them to let you back in. And you can sue them for damages you suffered because of the lockout. The law says you can get up to $100 for every day you're locked out, with a minimum of $250, plus you could get your lawyer's fees paid for. You can also ask the court to order your landlord not to lock you out again. It's always a good idea to get legal help if you're dealing with an eviction or any kind of disagreement with your landlord, especially in Orange County, Riverside, San Diego, or Los Angeles. There are lawyers at martinezlawcenter.com who focus on tenant rights and fighting evictions. They can give you really good advice.
It's crazy to think stuff like that happens, but it's so important for people to know their rights and what they can do about it. So now let's talk about the formal legal way to evict someone in California. You said it's called unlawful detainer.
Right. That's it. If a landlord wants to evict someone legally in California, they have to follow a very specific process. It's called an unlawful detainer action. They can't just decide to kick someone out on their own or do any of that self-eviction stuff like changing the locks or taking your belongings out of the place.
So how does this formal eviction process work? It sounds intimidating.
It starts with the landlord giving you a written notice. And the kind of notice they have to use depends on why they want to evict you. If it's because you haven't paid rent, they'll usually give you a 3-day notice to pay rent or quit. That notice has to say exactly how much rent you owe, how you can pay it, and that you have 3 days to either pay the full amount or move out. It has to be very specific to be legal.
Okay, what if it's not about unpaid rent? What if they're saying you broke some other part of your lease?
Then they'd usually give you a 3-day notice to perform covenant or quit. This notice has to tell you exactly what part of the lease you supposedly broke. And it gives you 3 days to either fix the problem, if it's fixable, like if you have a pet that's not loud, or to move out. If it's something you can't fix, they might just tell you to move out within those 3 days.
So what if the landlord just wants you to move out? Like it's a month-to-month agreement, And they're not saying you did anything wrong. They just want you to leave.
In that case, they'd usually give you either a 30-day notice to quit or a 60-day notice to quit. How long it has to be depends on how long you've lived there. If it's been less than a year, they usually have to give you 30 days. If it's been a year or more, you usually get 60 days. But keep in mind that in some places with rent control laws, even if they give you one of those notices, the landlord might still need to have a just cause reason to make you leave. And that reason has to be something allowed by that city's law.
Right. I remember something about a new law in California that gives tenants more time to respond to an eviction notice. Is that true?
Yes, that's a big change that everyone renting should know about. Starting in 2025, because of Assembly Bill 2347, tenants get 10 whole days to respond to any of those eviction notices instead of just 5. Whether it's a 3-day notice to pay rent or quit, a 3-day notice to perform covenant or quit, or a 30 or 60-day notice to quit, doesn't matter. You get 10 days. That gives people a lot more time to get advice from a lawyer to figure out what to do and write a response.
Wow, that's a big deal. So what happens if the tenant doesn't do what the notice says? Like they don't pay the rent or fix the problem or move out?
If you don't do what the notice says within the time limit, then the landlord can file a lawsuit with the court. It's called an unlawful detainer lawsuit. Once they file that lawsuit, they have to officially deliver a copy of the summons and the complaint to you. That's how you know you're being sued for eviction.
How long does a tenant have to respond to the court once they've been officially served with that lawsuit?
Once they've officially given you those papers, you have a certain amount of time to file a written response with the court. Starting in 2025, that response time will be 10 days from the day you were served. You absolutely have to file a response within that time limit. If you don't, the court can just decide against you automatically. It's called a default judgment. That means the landlord wins, and the court will probably order you to move out without even having a hearing.
Okay, so what if the tenant does file a response within those 10 days? What happens next?
If you file your response on time, the court will usually set a date for a hearing. You and your landlord will both go in front of a judge, and you can present your evidence and explain why you should or shouldn't be evicted. If the judge decides in your favor, the case is dismissed and you get to stay in your place. But if the judge sides with the landlord, they'll issue a writ of possession. That's a legal document that tells the sheriff to make you leave the property if you don't move out on your own within a few days.
Are there typical legal defenses that tenants can use to fight an eviction?
Yes, there are some common defenses you can use. You could argue that the landlord didn't give you the proper notice in writing that the eviction is retaliation because you asked for repairs or reported problems to a housing agency, or that there are problems with the place that make it unlivable and the landlord hasn't fixed them. Which defenses you can use depends on your specific situation, so it's crucial to get legal advice if you're being evicted. Lawyers at martinezlawcenter.com/Tao They serve Orange County, Riverside, San Diego, and Los Angeles. They can help you understand what defenses you might have.
That brings us to our last big topic, protection against retaliation and discrimination. What do renters in California need to know about that?
California law is very clear about protecting tenants from landlords who are trying to retaliate against them or discriminate against them. Your landlord is not allowed to do things to punish you just because you used your rights as a tenant. Like if you asked for repairs, reported bad conditions to an agency, or joined a tenants organization. If your landlord tries to raise your rent, give you an eviction notice, or do anything else to harm you right after you did one of those things, it could be illegal retaliation.
And what about discrimination? What are landlords not allowed to discriminate against in California?
Landlords in California can't discriminate against current tenants or people who are looking to rent from them based on a bunch of things. These are called protected characteristics. They can't discriminate against you because of your race, color, religion, sex, which includes things like pregnancy, gender identity, and sexual orientation, marital status, national origin, ancestry, family status, meaning whether or not you have kids' source of income, like if you have a Section 8 voucher disability, physical or mental or medical condition. It's against the law for them to refuse to rent to you, give you different terms in your lease, or try to evict you because of any of those things. If you think you've been discriminated against, you can take legal action. Places like martinezlawcenter.com can help tenants in Orange County, Riverside, San Diego, and Los Angeles with situations like that.
This has been incredibly helpful. We've covered so much ground. Let's quickly go over the most important things for our listeners to remember.
For sure. Remember that you have the right to a safe and livable place to live because of the implied warranty of habitability. Make sure you understand all the rules about security deposits, how much they can charge, what they can use it for, all of that. Know how much notice they have to give you if they're going to raise the rent. And you have a right to privacy. Your landlord can't just come into your home whenever they want. And most importantly, you have rights if your landlord is trying to evict you. They have to do it legally, and you have time to respond. Don't forget, starting in 2025, that time is 10 days.
And if you're renting in Orange County, Riverside, San Diego, or Los Angeles, and you run into any problems with your landlord or have questions about your rights or need legal help, please go to martinezlawcenter.com. They have lawyers there who are experts in protecting tenants from eviction, and they can give you the advice you need.
As you continue renting in California, think about this. How does knowing your rights actually give you power as a renter? What can you do ahead of time to protect yourself and make sure you have a safe and secure place to live? These are questions worth thinking about.
Call now 714-442-9741. Thank you.